Hello, welcome to the 13th Mental Capacity Act webinar. Can't believe it's our number 13. 13 is lucky for some, so we're really hoping that this is going to go well and we're not going to have any gremlins today. I'm Sue Farmer, you probably know me. Wanted to introduce the people that are going to be talking today, but before then, if I could just remind you of some housekeeping. If you have any questions to ask, just bear with me a second. If you could use the chat bar, so colleagues will be sat there live and answering questions as we go along, but then we'll pose any questions at the end of the sessions as well. We really like to hear from you with your questions because we like to know that there's somebody there listening to us. The session is being recorded, so if you do contribute to the questions or you speak at any point, just if you could bear that in mind. At the end of the session, you'll be sent a link to do an evaluation, and when you've completed the evaluation, you'll get the certificate. And as always, we do really appreciate your feedback. It helps us formulate what we're doing right, what we need to do wrong, what we've done wrong, and any changes that we can make or ideas for future training. So thank you very much for that. We've got 3 speakers today. I'm really pleased to say that we've got Becky Thompson, who's from Dorset Advocacy. Becky's going to be on first, and she's going to talk to you about the role of the Relevant Persons Representative, or the RPR, under the Deprivation of Liberty Safeguards. So thank you, Becky. We really appreciate your time in doing this, and I know that you're going to really enjoy listening to her. Then Natalie from our team, Nat's going to look at care home visiting, and with the current COVID regulations, and we know they're all subject to change. It's all really quite up in the air. So Nat will kind of pinpoint it at this moment in time as to where we're at. But obviously these things could change as the virus changes. And then finally, Val Cope from the team. Val's going to talk about capacity, and do you have capacity, and are you sure? And it's going to be a much more kind of in-depth dive into capacity, which I think you'll find very interesting to listen to. So thank you very much for being with us today. I can see we've got 64 people listening so far, so that's great. 67, it's going up. So I will stop waffling on, and I'm going to hand you over to Becky, who will be talking to you about the role of the RPR. So thank you very much, Becky.
Hi, my name's Becky. I am one of the IMCAs from Dorset Advocacy, and I've worked there for about 8.5 years. I cover a variety of advocacy roles as well as my IMCA role, including the paid RPR and litigation friend. This allows for consistency for the people we work with, as they often require support under several roles. Today I'm going to talk to you about the role of the RPR and Section 21a applications. I would be grateful if you could bear with me, as I'm not a natural public speaker. If I use any acronyms today and you're not sure what they are, please do ask. And also, if you have any questions, there'll be time for questions at the end. I'm using a couple of case studies today, and they have all been anonymised to ensure confidentiality. Next slide, please. I will refer to some case law during this, which I find really helpful, but it's not an exhaustive list. Starting with Cheshire West, which clarifies the test and definition for the deprivation of liberty of adults who lack capacity to make decisions about their residence and care they receive. The acid test is used to see if an individual who lacks capacity to consent to their care arrangements is being deprived of their liberty. It asks 2 questions. Are they under continuous control and supervision, and are they free to leave? The role of the RPR is guided by the Mental Capacity Act 2005. We have 2 key powers, the right to request a review of the authorisation and the right to access the Court of Protection. Our duties under that role, as an RPR, I must maintain contact with the relevant person and ensure they are supported in matters related to the DOLs. This could include supporting the person to raise a formal complaint, if appropriate, using the organisation's complaint procedure. I will try and establish the relevant person's wishes and feelings regarding the standard authorisation, to explain my thought processes when I visit a person, I will be thinking, what are their views on the care they are receiving and where are they living, where they are living? Is the care they are receiving person-centred? Do they have the opportunity to take part in activities that are tailored to their interests? Does their room feel homely? So, for example, is there personal effects in there, photos, etc.? And is this something that the person would want or would want if they could express their wishes? Are they being empowered to make choices that they are able to and being encouraged to be as independent as possible? Is the care the least restrictive it can be whilst also meeting their care needs? I will think about what the restrictions are on the person. For example, how is their medication administered? Is it given overtly or is it covertly? Covert medication is very restrictive and should only be used as a last resort following a best interest decision. The covert plan should be reviewed regularly. District Judge Bellamy gave some guidance over the use of covert medication in the AG case. Are they objecting to the arrangements? Justice Baker gave guidance to the duties and powers of the RPR in RD and others. This piece of case law is very helpful in giving guidance on what is an objection, and I will come on to that a bit later. Next slide, please. So I'm going to talk about June. June is an 84-year-old lady with a diagnosis of dementia. She was admitted into hospital following a fall at home and a long lie. She had not been eating or drinking properly at home and needed lots of encouragement on the ward. I was involved as her IMCA regarding a discharge decision, and I was also her paid RPR for the doles that was in place. I visited June in hospital on several occasions. She was confused in her speech and it was very difficult to establish her views and wishes due to her understanding. Due to June's confusion, she required staff to watch her constantly to try to prevent her falling. She kept trying to walk on her own despite her mobility not being good, and she could not recall needing a member of staff to support her walking. I felt that the doles was appropriately in place for June and the staff were trying to support June in the least restrictive way they could to meet her needs. When I met with June, she was not able to understand the information I gave her to weigh it up, but she seemed to enjoy having a chat with me and the company of my visits. I agreed with the assessment that June lacked capacity in relation to her care and where she was currently staying. Following a best interest meeting on the ward, a decision was reached that it was in June's best interest to move to a care home. When I spoke to June, she did not appear to object to this decision. I visited June a couple of weeks after she had moved. I allowed a couple of weeks before my first visit to give June time to settle into her new environment. By this time, there was a new doles in place for June at the care home. When I visited June, I was surprised by the difference in her, both physically and cognitively. She could not recall her stay in hospital. She had been quite unwell, so this is understandable. However, she could tell me the name of where she was now living, the type of establishment it was, and the reason she was now living there. June told me about in great detail about the layout of the home, what the staff did to support her, and the reason she needed this support. I felt that June was orientated to place and time and that she was able to weigh up the information we spoke about. I requested a review of her doles due to such an improvement in her cognition. Following a review by a best interest assessor, it was felt that June now had capacity to make decisions about the care she was receiving and where she was also residing. As a result, the doles was no longer relevant and the authorisation was ceased. Next slide. Thank you. So what is an objection? When I meet with a person, either as my role as a paid RPR or as an IMCA, one of the key things I'm considering is are they happy with the arrangements or are they objecting to them? We all have different personalities and we all express ourselves in our own unique way. This is the same for a person who is experiencing a cognitive impairment. Some may be very vocal or physical in their objections, where some may be quiet or withdrawn. Looking out for behaviour that may indicate an objection is really important. Establishing what that person's past views or wishes may have been also helps to build up a picture. It is helpful if the care staff can record every time the person says they want to leave or go home, even if they're referring to a home that was their childhood home. Also, recording when someone is packing their bags, putting a coat on, trying doors or exits, all of this builds up a picture of the consistency of the objection. If there is a trigger or a pattern, possibly sundowning behaviour, and it all helps to decide whether a court application is necessary, particularly if the person is not able to tell us themselves. As RPRs and IMCAs, our role is to work with people that have been assessed as lacking capacity for different specific decisions. We often get told that the person does not understand where home is. We know this, but we must consider what their views and wishes are or would be if they had capacity. My first consideration is, can anything be done to support the person to feel more settled within their environment? Is there anything that can be done to reduce the restrictions upon them, or is home a possibility? In RD and others, there is guidance that gives us the ability to work with the family and commissioning authority to see whether there are any alternative options or arrangements that can be made. If any of these can be done, then we can possibly address them without the need for the court intervention. However, if the person tells us they want us to refer to court, then we must, and RD and others explains this. Or if we believe that they would wish the matter to be referred to court if they had the capacity to do so. Another thing to consider is how long have they been objecting? A court application should be made in a timely manner. Next slide, please. The court protection can only oversee cases for people that have been assessed as lacking capacity to make specific decisions. There are two routes into the court of protection: a Section 16 welfare application, generally made by the local authority when there is concern about a person's welfare. You would come across this type of application, for example, when a person is living in their own home and there is concern that their care needs can no longer be met at home, but they are objecting to the decision for a move to a care home placement. A Section 16 application would be made to ask the court to approve a move against the person's wishes. With a Section 16 application, the person is entitled to means-tested legal aid for their legal fees, and the threshold for this is quite low. So it may mean that they end up having to fund their own costs for a decision that they have little control over. The other route is a Section 21a application. This is made when there is a current DOLS in place and is a challenge to this authorisation. I like to look at it as a review of the DOLS authorisation by the court. In this type of application, the person is entitled to non-means tested legal aid, so therefore will not have to fund their own legal costs. In line with the RD and others case, the RPR is duty bound to assist P to make an application to the court where it appears that P wishes or would wish to apply to the court of protection. If I am visiting a person subject to a DOLS that I believe is objecting, then I am responsible in making a Section 21a application in a timely manner. Sometimes I will need to make more than one visit to be certain of the consistency of the objection, and this also depends on where they're deprived of their liberty. So, for example, if the person is in hospital, I'm very conscious that I do not want to delay discharge, so it is often worth getting the application started after the first visit to ensure there is less of a delay for the discharge, and it can always be stopped if the person changes their views. It cannot be in anybody's best interest to remain in hospital any longer than necessary. My first step is to inform the MCA or the DOLS team that the person is objecting and that I intend to make a Section 21a application. I always try to copy the social worker into this email if I have their name and details. I then contact a solicitor to make an application. We use several different firms that specialise in this area. The solicitor will send me the legal aid paperwork to review and sign on behalf of the person. They will then make a start on completing the court application. This can take a couple of weeks depending on their workload. They will also contact the legal team for the relevant local authority. It really helps with timeframes if as much evidence as possible can be provided ahead of the first court hearing, so front-loading the application. The type of things that are asked for in the first directions order are a capacity assessment to conduct proceedings, an up-to-date care and support assessment, an analysis of options for residents and care, including balance sheets for each option, the cost of each option and how it would be funded, and if not, the reasoning for this decision, the local authority's view on which option is in the person's best interest, and whether the current care arrangements could be made less restrictive. It is difficult to say how long the court process will take because that varies with each case. However, I have found the more that all parties communicate and work together, the quicker and better the outcome is for the person. Ultimately, we're all there for the same reason, and that is what is in the best interest of the relevant person. Next slide, please. So Dennis is a 98-year-old male with a diagnosis of vascular dementia. He was a small, frail man. I became involved with Dennis when I received a referral as an IMCA for a discharge decision. Dennis was admitted to hospital following a fall in his garden late at night. Whilst in hospital, Dennis contracted COVID-19 and was transferred to a community hospital that had been designated as a COVID ward. In hospital, Dennis was accepting of all the support the staff gave him. There were no concerns with challenging behaviour and Dennis was settled with no indication that he was objecting. As a result, a DOLS had not been applied for, even though it should have been. Not objecting is not part of the acid test. As Dennis was on a COVID ward, I was unable to visit him in person, as at the time this was Dorset Advocacy's COVID policy. Therefore, I had to try remote communication, such as telephone and video calls. Despite being chatty on the calls, Dennis was extremely confused and was not able to express his views regarding the discharge. A best interest meeting was held and a decision was made for Dennis to move to an interim placement while the social worker explored whether home was an option. Not much was known about Dennis's home or his finances at that point, and so this seemed like an appropriate plan, and Dennis had not expressed an objection to this when I discussed it with him. Within minutes of Dennis arriving at the care home, his behaviour changed. He was throwing himself into the walls and furniture. He even managed to pick up an armchair and throw it at a member of staff. During this distress, Dennis injured himself and an ambulance was called. Dennis was taken into the acute hospital. Immediately on being in the ambulance and back on the ward, Dennis's behaviour returned to being calm. I felt that Dennis's behaviour at the care home was an extreme objection. He was not able to verbalise his views due to his cognitive impairment, but he was certainly able to show everybody what he thought. My view is that the hospital is a very clinical and easily recognisable environment, whereas a care home looks and feels more homely. A further best interest meeting was held and it was felt that it would be in Dennis's best interest to have a trial at home with a live-in package of care. If it had been decided that Dennis should be discharged to a care home, then we would have needed to refer the matter to the court for this decision due to the previous objection. The social worker established what state Dennis's property was in and whether it would be suitable for a living carer, what his finances were like, and also organised the package of care. A transition plan was written with contingency planning in case the trial broke down. Dennis was discharged from hospital to his home. I was informed that when he walked into his home, he appeared to recognise the environment. He did not seem upset that there was a carer in his home and he remained calm throughout. The trial was successful and this avoided the need to go to court. Next slide, please. John was an 82-year-old man with a diagnosis of dementia and a possible delirium. He was admitted to hospital following a fall. There were concerns about the condition of John's property. It required repair work to the electricity and the heating and was also in a cluttered state. It was reported that there was out-of-date food in John's fridge and that John was self-neglecting. A DOLS was put in place and a paid RPR visited John several times on the ward. John was consistent in his wish to return home. He was unhappy on the ward as it was noisy. However, following a best interest meeting, a decision was reached for John to move into a care home as it was felt that he required 24-hour care to meet his needs. The paid RPR made a Section 21a application. A considerable amount of work needed to be done to the property before a trial at home could be considered. John was assessed as lacking capacity to manage his finances, so a deputy needed to be appointed before any work could be carried out on the property. Therefore, the court agreed to an interim placement in a care home to allow time for the work that needed to be done and to avoid him being in hospital any longer than necessary. He'd been in hospital for approximately 3 months at that point. John agreed to this, providing it was not long term, and he settled quickly once he moved in. However, he was still adamant that he wanted to return home and described being in the care home as a period of recuperation. It took a long time for the deputy for his finances to be put in place, but once this had been done, work could start on the property. As John had been assessed as requiring 24-hour care to return home, he wasn't very, for a trial, it was felt a living carer would be necessary. John wasn't very keen on having a living carer as he felt capable of taking care of himself. However, he agreed because it was more important to him to go home than not having a living carer. John returned home. However, he found having the living carer too restrictive. He was unhappy, and this impacted on his behaviour towards the carer. John went through 3 carers over the course of 4 weeks. All parties within the court proceedings were in constant communication, and we had regular meetings. Rather than considering the trial a failure, we looked at whether the package of care could be adapted to better suit John. The package of care was reduced to 4 visits a day after careful thought and planning around how the risk could be mitigated. This worked really well, and John was much happier. He enjoyed the company of having different carers visiting, but also did not feel he was being so restricted. The court process from start to finish took about 2 years, but it was a complex case and was complicated by the pandemic. Not all proceedings take this long. I think it's a good example of joint working with the support of the court and how that can have a positive outcome. Finally, I just wanted to say that positive outcomes through Section 21a applications don't always mean returning home. It can be a move to a placement that is more suitable for the relevant person, or a reduction in the restrictions that may be ensuring the person gets out into the community regularly or has activities that they find meaningful. Thank you, that's me finished. Is there any questions? No?
Thank you very much, Becky. I can't see any questions in the Q&A, but if people do have some or they think of any whilst we're going through, then please post them in, and then we can either ask Becky at the end or we can send the answers out via feedback forms later. Okay, we're not getting anything in, so I will continue with mine. I'm having some troubles with my camera, so I might just turn it off rather than me being very jittery. Okay, so I'm Natalie, and I'm one of the Mental Capacity Act advisors. I'm going to be talking to you today about care home visiting during COVID-19 within the context of the Mental Capacity Act and the Human Rights Act. What I've tried to do is take us through from March 2020 to present day as best as I can, so we can fully appreciate the restrictions that people in care homes have faced. And I also want us to have a look at how we can utilise our own experiences of the restrictions to enhance our practice and to ultimately improve the lives of those individuals that we meet. So the COVID-19 pandemic has meant that all of us have faced restrictions on our human right to liberty and our right to a private and family life of varying sorts and degrees. This has ranged from not seeing family, leaving our homes once a day, not travelling, being deprived of social activity, and being restricted from education and work. but people in care homes have experienced even higher restrictions imposed upon them, and for a longer stretch of time. There has been some research done within this area, and this has found that the impact of this goes beyond increased mortality. So the lockdown restrictions have isolated care home residents from their family and friends, and the Relatives and Residents Association have found that this has significantly impacted people's physical and mental health. The Alzheimer's Society have also researched that this is particularly the case for people with dementia and Alzheimer's disease. So within this bracket of people, there will be individuals who lack the mental capacity to consent to their care and treatment, who have been disproportionately impacted. Now, this is echoed by the Equality and Human Rights Commission, who have published a report on how the pandemic has impacted our human rights. They have discovered that older people, ethnic minorities, and some disabled people, particularly those in care homes, have been disproportionately impacted by the pandemic. So whilst at times we have all been not free to leave our homes in the way that we have been used to, for most of us, we have been living with people whom we have chosen to live with. We have been able to form support bubbles with people of our choice. We have been able to meet with people outside of our homes of our choice, and we are now living very limited life restrictions. So I think the key here is that whilst these restrictions have been imposed, we have been given small snippets of choice along the way, but people living in care homes have not had this to the same degree. People in care homes ordinarily do not get to choose who they live with, who they socialise with. They will experience a loss of autonomy as they comply with some routines that are just naturally set by the care home environment. And in addition to this, through COVID, they have been restricted in seeing those they do choose to spend their time with. And for a very long time, they were not free to leave their care homes without then having to isolate for 14 days afterwards. So I'll talk to you briefly about the history of care home restrictions since the pandemic began. And in March 2020, we saw many care homes closing their doors as a response to the rising COVID-19 cases. This meant that people living in care homes could no longer have any visitors inside. In April, the official guidance was released to advise that family and friends should not visit people in care homes except for in exceptional circumstances such as end of life. 4 months later, having had no in-person contact from family and friends, the government advised that care homes should support one constant visitor to visit their loved one. But they continue to advise that visits should happen outdoors if possible, and social distancing should be complied with. In September 2020, the Department of Health and Social Care released new guidance following the concern over the new variants. And this consisted of stating that care homes located within an area of intervention should immediately move to stop visiting, except in exceptional circumstances. And following campaigning by various charities and organisations, guidance was updated, which stated that if a care home within a Tier 3 or 4 area, visiting could continue to take place with the use of substantial screens, visiting pods and at windows. So essentially really only outdoor visits, except for in exceptional circumstances. In addition, the adult social care winter plan suggested that if visits did occur indoors, then they should be supervised at all times. And as a little side note on this, it is important to recognise that supervised contact in ordinary circumstances could be viewed as a restriction on an individual's human right to a private and family life. Following this guidance, we experienced a wave worse than any previous, with death tolls in care homes at their highest. During an outbreak of COVID within a home, all visits are suspended, so I'm sure we can all appreciate that there were prolonged periods whereby many people were not able to have any meaningful contact with people of their choice. In early 2021, visits from one named visitor resumed indoors. And as part of the government's roadmap out of lockdown, they issued guidance on how this would be for care home visitors. From April, each person could have up to 2 named visitors, and they were able to visit regularly indoors so long as they tested negative via a lateral flow test, and an individual could have an essential caregiver who would also need to test negative before each visit. Other visitors would not need to be tested but had to visit outdoors only. And if there was a COVID outbreak within the home, then visiting would only be allowed for essential carers or for those visiting at end of life. In May 2021, the situation really started to change for people living in care homes. Over a year later, this new guidance detailed that each person living in a care home could have the following. 5 named visitors could visit inside. Other family and friends could visit outside. It was not a condition that visitors were vaccinated. And the government stipulated that these visiting decisions should be a collaborative process and consider the legal obligations under the Equality Act and the Human Rights Act. Now, pre-May 17th, those of us who have not been living in a care home have been able to experience some level of normality by going out more than once a day, being back at work. Children had been at school, play parks had opened, cafes and pub gardens had catered for us, swimming pools and gyms had opened their doors, and we had been free to travel further than our own hometowns. However, people living in care homes hadn't had such opportunities. I won't call them luxuries because in reality, these aspects of our lives are not ordinarily luxuries. Within the scope of a pandemic, I believe that we have probably come to see these aspects of our lives as a luxury because we have been deprived of them for some time. But within an ordinary England, we are fortunate enough to experience these opportunities as part of our day-to-day lives. Now, older people, people with physical disabilities and people with learning disabilities have faced discrimination in terms of these ordinary opportunities even pre-COVID. And that's essentially because our society hasn't made itself user-friendly for all abilities. So in addition to this, since March 2020, if they left their care home, they had to self-isolate for 14 days. And this meant that they couldn't leave their own room. And this was all on top of having limited, meaningful face-to-face contact with their loved ones. So from May the 17th, people living in care homes were finally able to go on outdoor visits to parks, beaches, gardens, medical appointments, visiting day centres, they could attend education settings, they could go to their work without having to isolate in their rooms alone for 14 days afterwards. So I'll bring us a bit more to present day now, and from the 19th of July, otherwise termed Freedom Day, society has experienced life with limiting restrictions. But the government and their guidance has made it clear that life for people living in care homes will not return yet to how it was pre-March 2020. So this current guidance sets out the following: that every care home resident can nominate an unlimited number of named visitors who will be able to enter the care home for regular visits. And there is now no nationally set limit on the number of named visitors who can attend at any time. Every care home resident can choose to nominate an essential caregiver who may visit the home to attend to essential care needs. And this essential caregiver should be enabled to visit in all circumstances, even if the home is closed due to an outbreak, but not if the essential caregiver or the resident themselves are COVID positive. Sorry, bear with me just a second. Okay. Named visitors and residents are advised to keep physical contact to a minimum, and physical contact like hand holding is acceptable if hand washing protocols are followed. Close personal contact, such as hugging, presents higher risks, but will be safer if it is between 2 people who are double vaccinated. and they're not having that direct face-to-face contact, and it's just brief contact only. And care homes can also continue to offer visits to friends and family members through arrangements such as outdoor visiting, rooms with substantial screens, visiting pods, etc. And as I'm sure you're all aware, from 16th of August, those who have been fully vaccinated will no longer have to self-isolate if they've been identified as being in close contact with somebody who has tested positive for COVID. For people living in care homes, this means that visitors to care homes are advised against visiting if they are identified as a close contact, unless the visit is absolutely necessary. Where visits do occur, visitors should have received a negative PCR result and a negative lateral flow result earlier in the day of their visit. Residents in care homes who have been identified as close contacts of someone who has tested positive for COVID do not need to self-isolate as long as they're fully vaccinated, and they can continue to have visitors as normal. In the event of someone testing positive in the care home, then visits are suspended for 14 days after the last positive case. I'm sure you can all appreciate that this guidance is complicated and lengthy. I've only very briefly gone through it, so if you do need more information, then please have a look on the DirectGov website. So I'm now going to have a look at the visiting guidance within the context of the Mental Capacity Act. And throughout the pandemic, the guidance has stipulated the same message when it comes to residents who lack the mental capacity to consent to visiting policies. And that's what you can see here up on the screen. So the principles of the MCA should continue to be adhered to. So the presumption of capacity to make decisions about the visiting policy still applies. And a person is not to be treated as unable to make a decision about the visiting policy unless all practical steps have been taken to help them to do so. A person is not to be treated as unable to make a decision about the visiting policy just because they make an unwise choice. And this might be who they choose to be their named visitors, for example. And if the person is assessed as lacking capacity to make this decision, then there must be a best interest decision made. And finally, this best interest decision should be the least restrictive of the person's rights and freedom of action. So if an individual is assessed as lacking capacity to make decisions regarding visiting during COVID-19, then a best interest decision should be made with the relevant people. So that would be their lasting powers of attorney for health and welfare, family, friends, and external professionals if it was felt necessary. And these best interest decisions must consider the person's well-being holistically and be a balance between risk, their well-being, their human right to liberty and a family life, but they also need to have consideration of the other residents living within the care home. And we are now in a position whereby we should be able to evidence the impact that a visiting policy has upon an individual. And so this needs to be carefully considered because it will vary from person to person. So to finish, I wanted to end on a picture that I felt captured the notion of being free. I'd like us to just forget the world of COVID for the next minute and purely focus on what life means for people living in care homes. There are a large majority of people living in care homes who are deprived of their human right to liberty, meaning their freedom is restricted. This is mostly done in their best interest, and this is where the deprivation of liberty safeguards comes in. We have all experienced restrictions over the past 18 months, and I feel this has given us all a unique opportunity to experience what this deprivation feels like. So how has this impacted on our emotional, social and mental well-being? Well, I think it's given us insight into how human connection contributes to our wellness, something that may previously have been taken for granted. It's enabled us to gain a better understanding of how accessing the outdoors and doing the things we love makes us happier. So imagine for a second that 2020 was how you would be spending the rest of your life, because people living in care homes who lack the mental capacity to consent to their care and treatment will always be subject to restrictions to keep them safe. And these people have experienced an unprecedented level of restriction due to COVID. So let's try and not forget how the last 18 months has felt for us when we are visiting people in care homes who are, by the very nature of their living environment, deprived of their liberty, because really, despite COVID, they always will be. But small changes can make a difference. So if we can try and move forward from this by making it better for those people, by thinking holistically and creatively, utilising the best interest balance sheet to help you really consider the wider implications outside of the risk when care planning. And I'm not suggesting that this is an easy balance, but we need to consider the individual differences, their life experiences, their values and ethics, when we're placing weight on the advantages and disadvantages of any decision that we are making on behalf of a person. So that is all from me today. I'm going to pass you over to Val. I apologise if it's been a little bit depressing at the end, reflecting back over lockdown, but I hope it's given you a bit of food for thought. And I apologise about not having my camera on either. It just kept freezing, so I thought it'd be better to turn it off. I'll hand you over to Val. Thank you.
Hello, I'm Val Cope. I hope you can hear me. I think I've unmuted. Just to say before I start, Becky's still here, so if you do have any more questions for Becky, but she's publishing under my name, so but it is Becky that's answering your questions about the role of the IMCA. I'm Val Cope, and I'm going to talk to you about capacity, and I know we've done this a lot. Capacity. I'm just going to try and move the slides on. Request control. See, I'm doing it all wrong as usual. Okay, so I think I can move the slides on now. Yes, I can. So I'm Val Cope, and I'm one of the MCA advisors. And I'm going to talk about capacity. And as I said, we talk about this a lot, but we do get so many questions about doing capacity assessments, and there are always sort of lots of nuanced things that come through. So I'm going to try and look today at you know, what happens when we are testing somebody's capacity, and we're doing this assessment for somebody with a mental impairment. Do they have to be, you know, so do they have to understand more than people without a mental impairment? Is it more difficult? Are the questions more difficult because they're not supposed to be, are they? I'm going to give you an example taken from a blog called Social Work, Cats and Rocket Science. And apologies if you've already seen this, but I'm just going to read this through quickly, and I am going to talk quickly because we're going to be running out of time. And if you do have any more questions, please put them in the chat bar as we go along. So this is a blog that's on Twitter. So if you have Twitter, it's worth having a look. And I'm just going to read it through. OK, it says, you are a social worker. It's a Monday evening and you've had one hell of a day. It started with back-to-back meetings. The first one at 8:30. Who arranges a meeting at 8:30 on a Monday? In the afternoon, a crisis developed regarding someone, and by the time you get back to your car for the drive home, it's gone 7 o'clock. It has been a stressful day. On the drive back home, you stop off at the off licence for a bottle of wine. You know you shouldn't. It's a school night, but you have to be back on the road the following morning, but nothing winds you down like a bottle of wine. Oh, need to go back. Can't. You tell all this to the guy behind the counter, maybe feeling a bit guilty for having a drink on a Monday night, and the shopkeeper says to you, are you sure you should be drinking tonight? Excuse me, you say. Are you sure you should be drinking tonight? You just told me you have to be back on the road in the morning. Did you know that 23% of all drink driving convictions are where the person was still over the limit the day after? Oh, don't worry, it'll be fine, but thank you for your concern. Well, I'm not sure I should be selling you alcohol. The effects of alcohol wear off differently depending on the age, gender, weight of the person. It can take over 12 hours for the alcohol units in that bottle of wine to wear off. Well, I'm not sure it's any of your business. I'll be fine. I'll just take the wine and pass on the advice, but thanks all the same. Anyway, I have one of those breathalyzers at home. I can check in the morning if I'm over the limit. What make and model is it? What? You just said you have a breathalyzer. What make and model is it? I need to be sure you're going to be safe. And it's not just you I'm worried about. Suppose you hit a pedestrian. I have a duty of care. So, is it the case that by drilling down enough, you can prove that anyone lacks capacity and link it to a mental impairment? I mean, if that was me and had a stressful day, maybe I was overtired, maybe I wasn't kind of thinking clearly enough to make a decision about whether or not I should be drinking on a Monday night. The other thing that we have to take account of is that assessors can be perceived to be in a position of authority. And if you're being questioned by somebody that you think is a person in authority, you might feel very anxious about that. You might feel that you're being put to the test and you've got to pass somehow. And that might actually impact on your ability to answer questions. So the guidance from 39 Essex Chambers and case law is that we have to remember that it's important that P has to prove nothing. We should be assuming capacity unless proven otherwise. So that's just a thought. The other question I've often been asked, and I'm sure others have as well in the team, is can we group decisions together? This often comes from care homes who will say, well, you know, have I got to do a capacity assessment and a best interests decision for every aspect of this person's care plan? So looking at this, I looked at this bit of case law is very recently published. And this is about a young woman. She's just turned 18, and the court was asked to assess her capacity or to make a judgment on her capacity in 7 different areas. And there's some guidance given about this area about grouping things together. So this young woman was in court to decide on these areas. She had been diagnosed originally as a child with ADHD, with fetal alcohol spectrum disorder, and with specific difficulties with cognition and speech and language. Her expressive language was identified as being quite good, but her receptive and processing skills were said to be only those of a child aged 7 to 9. But she did not, however, have a learning disability. And the other thing possibly to mention is that she'd given birth to a baby boy shortly before turning 18, and the baby was actually subject to Children's Act proceedings and was in foster care. So the conduct of proceedings, this was Justice Headley, I believe. Yes, Sir Mark Headley, who gave this judgment. And what he said was that she'd already been through some court proceedings because she'd been in the family court, and that the issues in the family proceedings can be quite clear and stated quite shortly, whereas the issues in the Court of Protection are more complex. So because she was thought to have capacity in the area of the family court, did that mean that she had capacity in the area of this Court of Protection? What he decided was that she lacked the capacity to conduct these proceedings because of being unable to weigh the relevant issues, but also being able to understand some of the key ingredients about being in court, about what her rights were, about what was being considered, and that given the position of the parties, they decided that they would go with lacking capacity. Capacity to manage affairs was another area that he looked at, and the judge said that her example, the example of using her money, could have been illustrative of making unwise decisions, but generally that she was unable to grasp all the key ingredients that would have to be weighed in order to make decisions about her affairs. So she was identified as lacking capacity in that area. It was thought that this was a sort of more controversial area, but residence and care, they're often considered separately, but the point he made here was that often the two things are quite interrelated, and certainly when we do things like deprivation of liberty safeguards capacity assessments, we often put those two things together. So we talk about capacity for care and accommodation in one sentence. They are separate things, but he gave an example of somebody who has serious physical disabilities. The issue of residence then is quite inseparable from that of care. In the case of this young woman, it was the fact that she was possibly unwilling or unable to recognise the necessity of having care, and that the impact of not having care would have on her well-being. That meant that she lacked capacity. His view was that she overestimated her own ability to keep herself safe, and that she underestimated the consequences of being independent. The other point he made was that when you deal with severe emotional difficulties and deficits, it can be very artificial to put things into individual pigeonholes, because the impact of the person's emotional state will impact on all of those areas possibly. And often they are deeply interrelated. That's not to say you can just lump everything together. They also did a capacity assessment. He gave judgment on her contact with others, and on the evidence he decided that she lacked capacity to make decisions about contact. She had some issues in the past where safeguarding had come into play because of possible abuse by others. And he also talked about fluctuating capacity and the fact that the potential for her capacity to fluctuate often depended on whether she was calm or distressed or anxious. One of the doctor's views that gave evidence actually said, though, that even at her calmest, CMW did not achieve a level of functioning that would amount to having capacity in relation particularly to residence care and contact. He also reminded us, though, that CMW is only 18 and teenagers are prone to make unwise decisions because it's often the most effective way for them to learn. However, her functioning was affected by matters that were much more profound than just teenage angst, he called it. Contact, we've done contact with others. Social media, I don't think was actually there was any evidence brought about that. But it was thought that she probably lacked capacity in that area. Sexual relations wasn't discussed really. But what he did do was he said during this judgment that he had to remind himself that he has to decide the matters of capacity without regard to the welfare consequences. So irrespective of the outcome, if somebody has capacity and they're making an unwise decision, in the end, that's what you have to go with. If we do go to court and don't take the evidence that supports that somebody lacks capacity, the judge then doesn't have any other choice except to say, well, that person has capacity because it hasn't been proven otherwise. He also talked about the dangers of breaking things down, as we said, into individual pigeonholes and putting things into silos of things that are mutually incompatible. Or sorry, reaching mutually incompatible conclusions. And at times it becomes artificial to be to try and separate things out that are very interrelated. So that's what he said about grouping things. Just trying to move this on again. But also another interesting bit of case law, and you might have seen this one before because this is a bit older, this is from 2014, about a woman with schizophrenia who had a gangrenous foot, and her foot actually became mummified and fell off, but the doctor still wanted to amputate her leg. 3 different doctors assessed her as lacking capacity to make this decision. But what the judge in this case said, this was Justice Jackson, I think it was, that all she needed to understand was the purpose and effects of the treatment. He said that, let me move this on again because this, back one. That what they'd done was they had tried to assess her capacity based on different perspectives of medical opinion. They'd all talked to her about 3 different types of amputation. The first one was below the knee, then they talked about an amputation through the knee, and then they talked about an amputation above the knee, all of which had slightly different bearing on her mobility and how she was going to manage after the amputation, when actually they just needed to be talking about what was her view on having her leg amputated, weighed against the risk of not having it amputated and possibly death. So this was the consequence possibly of not having her leg amputated. If it got more infected, more gangrenous, she could have ended up with septicemia and died. And that was what the crux of what she needed to know, not all the nitty gritty details of the different types of amputation. So he felt that actually it had been unfair to do that, to give her so much information, more information probably than most people would get, because they'd assessed her capacity so many times. They just gone back to her with lots more information, and actually made it more difficult for her to express her wishes. So his judgment said that you just need to understand the nature, purpose and effects of the proposed treatment and have a broad general understanding of the kind that are expected from the population at large. That if you're indecisive or avoidant or vacillating, that's not incapacity. That's possibly the same as if you're uncommunicative, if you just don't want to answer, that's not incapacity. That's possibly just the same as any other human being would be in a situation that they find very stressful. So treating each type of amputation was impractical and unnecessary to distinguish between those, because it actually diminished the scope of her capacity. And the final thing I thought I'd share with you is just this little quote, that we shouldn't ask more of people whose capacity is questioned than those whose capacity is undoubted. And that was Peter Jackson. And this is from this is a tweet from Bradford MCA, and they put their little quotes on Twitter every now and again, and they're just very good at reminding us of some of the fundamental important things about the Mental Capacity Act. And that's all I have to say. So I'm going to hand you back over to Sue. And if you have any more questions that we haven't had time to answer, we'll try and do those later.
I am. Thanks ever so much, Val. So can I just start by thanking both Val, Natalie and Becky. I apologise.
Can't hear.
Sorry, it's been told you can't hear me. I'll say all of that again. I do apologise. Yeah, can I just start by thanking Val, Natalie and Becky for the training this afternoon. Really appreciate it. I had to duck out in the middle because I had to go to another meeting, so I haven't caught all of it, but I know that you will have found it really interesting, and I've enjoyed looking at the questions in the chat bar. I'm slightly freaked out by Val's mummified foot. That's trumped even a gangrenous foot. I'm struggling with that one a little bit today. But I think we never get bored of talking about assessing capacity, and we've always got something to learn, always, and it's we'll continue to talk about it and talk about assessing capacity, but I think I'll finish by thanking you all for attending. I can see that we're up to 91 people that have joined us this afternoon, so that's phenomenal. We really appreciate that. If you've got any more questions, you want to pop them in the question and answer bar, please do now. If not, I can see there's another one there. No, it's okay. No. So we've answered some of the questions as we've gone along, so I hope that's helpful. If I could remind you to do your feedback forms and let us know what you want us to talk about next. We're happy to. We were talking about perhaps trying to actually run the cats and social work podcast thing for you during one of these sessions, so we'll try and look at doing that, because I know our colleagues in Bournemouth did that and they really enjoyed it. So I will finish by thanking you and by saying also it is a Tuesday night, not a Monday night, so if you wanted to have a glass of wine tonight, I don't think you need anyone's permission. So thanks very much for being with us all, and we will see you back in October.